Hi, everyone. This is Phil Travis here, and this week just wanted to do a very brief presentation on an overview of issues of privacy in the post-September 11th world, and also a brief discussion of the principle of separation of church and state. So, the first time that we had governments wiretapping citizens of the country was not after September 11th. Actually, the first times that we really started to see this being conducted were in the 1960s during the Vietnam War. Of course, administrations like the Johnson administration and the Nixon administration conducted illegal wiretaps on a number of enemies that it associated with the anti-war movement and so forth during the Vietnam War. However, the technology that has emerged in the world in the last 20 years, as well as changes in terms of how we understand national security, has really changed everything. And of course, this was most driven by the events of September 11th, 2001. After the terrorist attacks of September 11th, 2001, the United States was directed through leadership with the George W. Bush administration to create the USA Patriot Act, which has been renewed several times. And part of the Patriot Act, there's a number of elements of the Patriot Act. There's a number of amendment rights that are compromised. There are components of the Patriot Act where in certain situations, for example, your Fourth Amendment freedom to be free of search and seizure without a warrant is compromised, for example. There are issues when it comes to privacy, when it comes to being held without trial that, if deemed related to terrorism, are compromised by the Patriot Act. Privacy, of course, has been a big issue with the Patriot Act as well. Now, in the Constitution of the United States, there is no formal right to privacy, albeit the Supreme Court has, over a number of different years, established through a number of different clauses from the Fourth Amendment, for example, in the Constitution, have very much established that there is a principle to a right of privacy. And when the wiretap programs led by the NSA, which was under the direction of George W. Bush and Dick Cheney during the early phases of the so-called war on terrorism, while the NSA constructed its new and aggressive wiretap program, many people that were part of the NSA in leadership actually resigned because they considered the action to be fundamentally illegal. However, individuals associated with this in the NSA, ultimately the ones who really were the architects during the Bush administration of the wiretap program, obviously made the argument that because it was a national security concern, that the Constitution warrants that if there is a clear and present danger, that the United States has some unprecedented powers to maintaining the security of the United States. The NSA, following September 11th, created an elaborate program, and it was a huge program that involved massive computer servers that were designed to track internet searches and were designed to collect metadata on people's phone records. And of course, all of us probably are aware of this, right? I mean, this has been big news. It was, of course, Edward Snowden who, a few years back, has infamously or famously, depending on how you look at the situation, released information through journalists like The Guardian, the British newspaper, and through this released certain documents that exposed the NSA wiretap program. And this, of course, has been highly controversial for the United States. And the metadata program, as it currently exists, actually will cease to exist in its current form in the months ahead, as Congress has refused to renew the full program, if you will, that was in place just months ago. And this, of course, happened with a great deal of controversy in Congress, as individuals like Rand Paul, for example, filibustered the renewal votes on the Patriot Act, and individuals like Mitch McConnell and, of course, the Obama administration fought for the continuation of these programs. There's an issue, there's a concern here with the NSA's program, and many people will argue that it is illegal, that the Americans have a right, that effectively it's a violation of your Fourth Amendment right to have your internet searches and your phone conversations effectively chronicled in at least some form. And so there is a significant concern that this is a fundamental violation to rights to privacy in the United States, and that it's unnecessary to fight terrorism. There's others who argue that, the war on terrorism, the post-September 11th world, that this is a national security crisis, that we're at war, and that we need these types of things to keep ourselves safe. Regardless of which side you fall on this issue, whether or not you believe that the government should be allowed to keep, and when we say metadata, we mean effectively collecting massive amounts of information on everybody. So the point of saying this, and what matters about this, is that this program was never designed, despite what individuals during the Bush administration and the Obama administration said publicly. This program, and we know this through the information provided by people like Snowden, this program was never intended to target specific people. It was intended to collect mass surveillance on the American people. And now, of course, it's not to say that the justification for mass surveillance was just to, surveil, but or some other like malevolent purpose, but simply that the government has been collecting mass information on the American people, and some people find this to be a great concern because of it's deemed a violation of people's rights to privacy, and people are concerned that the government is overstepping a very fundamental line. And people who are opposed to it generally would argue that you have to do these types of things, but you should do it on people that you have suspected leads as potential terrorists, or people who call certain places, or people who search for certain websites, flagged websites, for example. There are others who would argue that you need the mass kind of broad across the board collection because it's easier to catch potential threats. It's very difficult to say. I will say that this is not the first time in the history of the United States that we've had a marginalization of various types of freedoms during a time of war, or at least a time of national security crisis. The first time was during the so-called quasi-war, during the presidency of John Adams, our second president. There were, during that period, you could be imprisoned for speaking out against the Adams administration. And that had to do with a conflict with France. There was also, during the Civil War, the Lincoln administration, because of that war, in the border states, the states that had slaves that had not seceded, like Maryland and Kentucky, for example, Missouri. In those states, the writ of habeas corpus, just for example, the right to not be held in jail without formal charges, that right was actually marginalized because of a need for security. During the First World War, the Wilson administration pushed through the Espionage and Sedition Acts, and these also resulted in stringent regulations when it came to free speech against the government. And in fact, some very famous individuals, particularly Eugene V. Debs, the famous socialist activist in the United States, was actually imprisoned during the end of World War I for speaking out against the Wilson administration. Of course, there's also other times, and you could look at the 50s and the 60s. There's numerous times in which people's liberties were being violated more or less or illegally, or on the basis of allegations of communism. But I think the big question right now for the American people is less whether or not this has ever happened before. I mean, of course, in one respect, it has never happened before. And what I mean is that we've only recently had the technology to do these metadata collections. This is a new technology. Being able to collect metadata on people's phone records was simply not possible in the past. And so changes in technology and changes in how we communicate has really changed the game in terms of privacy. So that's certainly new. But it's not the first time that national security crisis has been used to justify a limitation on people's liberties. And I think the big question here is less whether or not that's ever happened before, because it clearly has, but more, will it become permanent? And if it becomes permanent, that's probably something that the American people should always be very concerned about. And the reason why that's the question is because as long as there's a legitimate international terrorist threat, it seems that it will be difficult to justify taking apart these types of programs. And when you consider the fact that terrorism is not a specific enemy, we are not talking about a particular country or even a particular group. Terrorism is a type of action, and it is probably something that we could never truly defeat in entirety, because it's not a place, it's not a country, it's not a one particular group. It's an ongoing threat. And so I think because of that, Americans have to wonder if we've not entered into a new kind of realm, a new world, a new technological world in which past ideals of privacy will be ultimately given way to the needs of national security. And so that's one of the big questions. And there's, like I said, the Patriot Act marginalizes not only issues of privacy, but also issues relating to the Fourth Amendment, as you saw in the case of Boston. Also, you see in the post-September 11th period, you see marginalizations of the writ of habeas corpus, the right not to be held without a trial. You see that's the issue with Guantanamo right now. Guantanamo, we have people, many of which who could be in the wrong place at the wrong time, but you have people who were captured in areas of suspected terrorism internationally, and they're held in Guantanamo without a trial, without due process, and they've been sitting there for over 10 years in many cases. And the reason that's controversial is because that's a violation of the Fifth Amendment under which the United States is supposed to operate. And so these are some of the big concerns with the kind of new war on terror era, the post-September 11th era. And the big questions are whether or not these changes will become permanent. And if they do become permanent, will they be steps towards an increasing loss of freedoms for the American people? I don't like to say it like that because it sounds like, kind of a slogan almost. But the big question is really, if you give up certain freedoms permanently in one area, does that mean ultimately you will step back on others depending on the scenario? So these are really the issues that the American people are dealing with on this particular issue. The other one I wanted to briefly mention was the principle of separation of church and state. Separation of church and state is really, perhaps the most fundamental principle behind the United States. The United States, if you look to the last comment on the screen, the United States is a product of the Enlightenment. When we say the Enlightenment refers to a period in the 1600s and the 1700s in which great philosophers and thinkers devoted themselves to using reason to unlock the natural laws that governed and organized our existence. And so everyone from Isaac Newton to John Locke to even Thomas Jefferson were all Enlightenment thinkers. And what this simply means is that they were using reason as a way to find the best functioning of the world. And one component of the Enlightenment period was that Enlightenment thinkers proposed a new way of governing, a form of government that challenged the notion of monarchy and instead promoted the idea of representative governments in which people all have natural rights, okay? Natural rights that you cannot have, like these hereditary divine right monarchies, that those violate individual liberty and freedom. And so many of the great Enlightenment thinkers came up with this concept that, in fact, there existed natural rights that governments had to protect, and that the best form of government was probably a representative form of government, that was the most natural and just form of government. And one of the most fundamental principles of this is this: the product of this are nations that move away from associating themselves with monarchies or with religions towards countries that are secular and driven instead by the principle of reason when it comes to their justice. The United States is a product of this. The founders of the United States, like Thomas Jefferson, for example, they are children of the Enlightenment. They were creating a country that was designed to be a secular nation whose forms of justice were based on modern notions of reason and of natural rights. Okay? So Thomas Jefferson is one of the founding figures of the country, one of his great contributions, and he recognized this. This is why this got on his gravestone, while his period as president did not. He had kind of it was a tough time at being president when Jefferson was president, and as it is for many people. And he actually left the presidency off of his gravestone that you can see up at Monticello. But one of the shining achievements for him was the Virginia Statute on Religious Freedom. And actually the phrase separation of church and state comes from Jefferson, more or less. This established the principle that the government was effectively separate from church, that a government could not affiliate itself with a particular religion, and that a particular religion should not affiliate itself with the government. The basis of this was that the government was, while not like atheistic or something, I mean, many Americans are religious, and many people in government are religious and believe in some kind of God, but the principle was that the government as an operating body should be a secular government that was separate from religion, and that the people of the country theoretically should have the right to adhere to whichever form of belief they choose freely and without discrimination. So you should not, you have no religious qualification to becoming a member of the government, basically. So separation of church and state. This is part of the First Amendment, and it's been established through precedents with numerous Supreme Court cases. And this is why when you have a situation in which, for example, a public school has, say, the Ten Commandments up, public schools are state-funded institutions, and if you have a situation where there's people that are offended by that, then almost unanimously the Supreme Court or whichever higher court, maybe an appellate court, will rule that it has to be taken down. And the principle is the basic principle of separation of church and state, that religion and church should be separate from government. It doesn't mean, like in the House of Representatives, for example, you have a prayer at the beginning. It doesn't mean that that government is fundamentally devoid of all kind of religious behavior, but it means that theoretically the structure and the organizing and the functioning of the government is supposed to be as separate from religion, and that the government should function as a secular government that bases its principles of justice upon reason, not upon necessarily a particular religious group, and that the individuals who serve in our government should not be based on particular religious affiliations. So it's a pretty fundamental principle in the country, and it's one that has been interpreted different ways, but generally speaking, the courts have all found that the principle that organized religion and government should remain effectively separated is pretty fundamental. Anyway, I hope this is pretty clear, and if you have any questions, let me know.